and welcome again. Last time the topic was the science of justice, with specific reference to an essay of that name by famed philosopher Lysander Spooner. I hope that all who saw that video have since accessed that essay from either the Voluntarist Academy website or other sources from which it is available. It is downloadable in written form from the VA site, and reading while listening is an aid to memorizing the core principles and statements. Having defined a concept of natural justice, a discussion is needed about how to administer justice in the real world. And for this, we turn to the philosophy of law, which is essential if we are going to define what type of laws are acceptable to the community. For the basis of this talk, I'm indebted to Professor Nick James of Bond University, Queensland, and I commend his series of talks to those seeking a primary understanding of the main schools of thought on this topic. Links are in the comments box. There are 5 short talks titled Introduction to Jurisprudence, and we'll be looking at the second and third of these in précis form. The 4th and 5th in the series are really developments of the concept of legal positivism, the subject of video 3 in that series, to which I'll refer later. Professor James defines 4 main schools of thought around jurisprudence, or the philosophy of law. These are 1. Natural law theory, 2. Legal positivism, 3. Economic analysis of law, and 4. Critical legal theory. Let's deal with these in turn. Natural law theory, as intimated in Spooner's essay and many of my talks, is the oldest of these. It sees law as a set of rules that reflect and enforce a set of higher principles, which can be defined as God's laws, laws of nature, or simply as objective principles of morality and justice. This school states that these rules are discoverable by reason and are superior to laws created by a state. They are universal in the sense of applying to everyone and are unchanging. 2 ancient examples of those familiar with this school are Aristotle of 384 to 322 BC and Cicero 106 to 43 BC. The latter's famous aphorism, lex injusta non est lex, meaning an unjust law is not law, was supported by 17th century philosopher John Locke, in almost exactly the same words, and by many other proponents, including the English Saxon kings and those who composed the Magna Carta in 1215. This school lost ground during the period when English and European jurisprudence became increasingly under the sway of legal positivism between the time of Magna Carta and the 20th century, but has regained much of that with the acceptance of the principles of universal human rights and the concept that wartime atrocities, for example, should be prosecuted after the end of hostilities. So what is legal positivism? It's a school that has 3 main tenets. A, we should focus not on what the law should be, but on what it is. B, law is created by human beings and is therefore a social contract. This is termed the social thesis. C, there is no necessary connection between law and morality. This is termed the separation thesis. Here are some of those who have promoted the concept of legal positivism. Pause the video and read the comments made by each. Some may be surprised to find John Locke, one of the foremost protagonists of individual rights, making the statement seen here. But is it really contradictory to the concept of individual liberty? If we ask the question, what or who constitutes the sovereign or supreme government, we leave open the option that it allows for the individual to fulfill that role, as exemplified in Locke's more famous statement, every man has in his person his own property, and that belongs to him and no other. Or, being all equal and independent, no one ought to harm another in his life, health, liberty, or possessions. But moving on, here we see Jeremy Bentham differentiating between the roles of the expositors of law and the censors of it. Again, the question here might be, why should the opinions of the expositors of law exercise any precedence over those of the censors or critics? From whence comes such authority? What is the objective test to determine whether either view is correct, or both either wholly or partially incorrect? Is there not a case for a non-coercive approach to law, with the final judgment being rendered by as close a reference to the local or individual level as possible? Here we have John Austin, whose view is primarily that the law is a set of commands from a sovereign, backed by a threat of sanction. There is no suggestion of any connection between law and morality. Perhaps more in line with the thinking of Thomas Hobbes. Again, the question is, from whence does this sovereign's authority derive? A more subtle line of thought is expressed by Hans Kelsen. Kelsen stated that law is a scientifically rational system of coercive norms that form a hierarchy. Thus, a traffic law derives its legitimacy from a traffic act passed by a parliament, which in turn derives its legitimacy from a state constitution. In the case of an Australian state, that constitution allegedly derives its legitimacy from an act of the UK Parliament. But from whence does the UK Parliament derive its legitimacy, if indeed it has any? In Kelsen's analysis, he found that ultimately everything depended on what he termed the Grundnorm, which he said varied from jurisdiction to jurisdiction and was often based on a non-legal concept, perhaps political, social or cultural mores, like customs. H.L.A. Hart lived entirely within the 20th century, 1907 to 92, and devised a system of classifying laws into primary and secondary legal rules, supported by an ultimate rule of recognition. This rule of recognition determines the ultimate validity of primary and secondary rules of law, and derives its own validity from being accepted by legal officials. How convenient. All you need is a pile of money, a qualified judiciary that is on board with your theory, an army of paid hired enforcers, and away you go. You can have your very own country to run. An empire even, if you're a particularly skilled and ruthless practitioner. Again, as with all the other legal positivists, the question arises, why are the opinions of people qualified in arcane legalese of any more qualitative value than those of people who are willing to be guided by morality and abide by natural law? Are not highly qualified people as prone to the foibles and corruptive temptations as anyone else? What if they misuse their positions of power and abuse the basic rights and liberties of non-legally qualified folk, as have so many legislators throughout the millennia of recorded human history? To be fair, Hart did stress that law should have a minimal moral content to encourage adherence, recognising that an immoral law was less likely to be obeyed by the population. He was certainly right about that, wasn't he? Look at the problems that arose with prohibition in America. Not only was that law not obeyed by hefty proportions of the people, but it encouraged the upwelling of far worse social and political problems such as gangsterism and political and judicial corruption on a massive scale. Our own observations confirm this concept. How many hundreds of traffic offences, mostly victimless, are committed every day compared with every murder, rape, armed robbery or violent assault? Most people are willing to comply with natural law and not harm their fellows, while it's glaringly obvious that they attach far less importance to complying with rules that simply interfere with their everyday rights, such as how they travel about in their own property. Another problem with having positive laws is that mandated minimum standards tend always to become maximums. People take the attitude, well, this is all I have to do, so that's all I'm going to do. Once, many decades ago, I drove without a licence for 3 years, and I was never a more careful driver than during that period. There's nothing like knowing you aren't covered by insurance to make you super careful and attentive. Others I've spoken to who did the same bear the same testimony. While I may have been breaking the law by not paying taxes on my own property or getting official permission to move about, I was nonetheless aware that I was responsible for any damage I may have caused and would have to account for it. I'm not suggesting that people should do that, although there are some who do, and surely it should be an option for them to insure themselves and their property against accidental or malicious damage without having to sign over ownership of their vehicles to an arbitrary authority by registering them to a specified business corporation calling itself the government. That's been a bit of a digression, and there are still two other schools of thought on jurisprudence to consider. These are the economic analysis of law and the critical legal theory. As I mentioned, they are really outgrowths of the legal positivist school and encompass such concepts as influencing the direction of legislation from considerations outside of law, such as social, economic, or cultural factors, sociology, psychology, and so forth. This school looks at influencing people's behaviours with incentives for compliance or sanctions such as fines or restrictions on certain activities for offenders. This school of economic thinking works on the premise that people who have objectives tend to be rational in how they go about achieving them and seeks to devise means to encourage people to behave in accordance with rules that may be emplaced and enforced without the input of many of those affected by them. In summary, it looks for ways to make the law more efficient, and one of those is to devise rules that, when enforced, produce benefits which outweigh the costs. One can see why this particular cohort would be antithetical to the concept of trial by jury, whereby a single recalcitrant juror, from the legislator's point of view, could undo the work of the whole system in a case simply by refusing to convict an accused because they judged the law involved to be immoral or unjust. Such cases would produce a loss, and if sufficiently numerous, could cause judicial systems to shrink from prosecuting such cases. The critical legal theory school includes concepts such as legal realism, critical legal studies, feminist legal theory, and critical race theory. These are more complex issues beyond the scope of a short video like this, but suffice it to say that when looked into, which I encourage the viewer to do, they basically stem from the inbuilt inadequacies of the current and historical legal system to address core issues of people feeling disempowered or oppressed by arbitrary rules laid over them without their consent, or, if consented to, producing unforeseen consequences, which cause disquiet on more remote planes than the original question. We see from the length of the history of the legal positivism school that it has over many centuries tinkered with the concept of natural law, actively obscuring it from the view of the common people and shrouding it in arcane language and symbolism, each step leading inexorably to the next, as the true purpose of the law, which is to uphold natural law, gets buried ever deeper in complexities which the average subject is too distrained to unravel whilst dealing with the increasing exigencies of everyday life. Whether this obscurantism is deliberately planned is for each individual to concern for themselves. But this writer is in no doubt that it is less the result of accidental inefficiency than careful manipulation, aimed at increasing the hold of arbitrary power by individuals who see themselves as somehow elite over their lawful equals. The increasingly harsh repression of individual freedoms, aided and abetted by a morally moribund constabulary, gives the lie to protestations of mistakes and misfortunes by those who increasingly see themselves as rulers rather than servants of the people. The time is now well past when everyone concerned for their own or their children's freedoms needs to be doing whatever they can to spread this information and the principles of adherence to moral law as far and as wide as possible. Form groups to campaign for the introduction of proper trial by jury courts. That is the fastest way to regaining control over lawless governments. Write to MPs, public servants, police commissioners, etc. Devise methods to demonstrate in a non-combative manner that we are no longer willing to be dictated to, that we don't recognise the principle that a few specially qualified legal experts have the right or authority to dictate to us by coercion and force, insist on our lawful rights. It may not seem as if one individual can accomplish much, but the more voices that are raised, the more will be raised, until it becomes a frightening clamour for the bullies trying to enslave us. Thank you for watching.